Yes, Mr. Selby, we're going to look at something in your skeleton.
Yes, a photograph. I just wanted to talk about the interrelationship between the EPS and the fire barriers. And there's a photograph in my skeleton, so that's tab 10 of the core bundle, page 67.
Yeah.
And this is a photograph of what you would see if you were to peel off all the render that you would normally see on the walls. So
yeah.
What sits behind is the white is the EPS. It's essentially thick blocks of polystyrene that gets fixed to the walls. And then sitting above the white EPS is a grey-brown colour, which looks like rock wool or mineral wool, and that's the fire breaks.
And are those, is that on top of the, it's not quite...
So you're looking at the face of a wall.
Yes, and the render's taken off.
So the render's been taken off, and you see...
And the mineral wool is in strips?
Yeah, in those thick strips.
Bands.
Bands, and they're supposed to go to the full depth of the insulation.
Right, okay. And so there's the mineral wool in bands, and so the EPS
yes
is above and below it.
Above and below, and the bands of the mineral wool, the fire barriers, they sit at each floor level.
Okay.
The basic idea being, if there is a fire in one flat, it's contained to that floor level.
Yeah.
It doesn't rise or drop.
Yeah. And the EPS system,
the stow system.
the stow system. We can see there that's a blockwork wall, can't we? Behind where they've chipped away at the EPS at the bottom. What's that?
Oh, it could well be. You're right, my lord. Just there at the bottom in the middle. My recollection was it was concrete behind the original substrate of the tower.
All right. Well, whether it's concrete or blockwork or brickwork, it doesn't matter. There's what it is.
Yeah.
So the stow system.
Yes.
Consists then, looking at this photo,
yes.
of what? The mineral wool and the EPS.
Yes, and then you render over.
And the render is.
It is. I think it's an acrylic product.
Okay.
There's obviously layers of render.
Yeah, fine. Thank you.
So, the purpose of the fire barriers, as I've said, is to limit the spread of fire within the system itself, thereby restricting the area affected by fire. You need the fire barriers because you have combustible insulation, the EPS.
Yeah.
Now, I don't know if you want me to make that point good or you're willing to accept that from me, but if you need a reference for that, there is a Stowe report relating to these towers, and that's in the supplemental bundle, tab 3.
Okay. Just give me the reference page.
So the report starts at page 26, and it's unnumbered, but 4 paragraphs down explains the role of the fire barriers and the insulation.
Okay.
And you see similar at page 29, 3 paragraphs down.
Okay. Yep.
So that takes me to what was my third point in relation to pleading, which is that the defects in the fire barriers and the EPS are not independent, unconnected defects. On the contrary, the defects in the fire barriers and the EPS are interconnected and go to the integrity of the system as a whole. You've obviously got the point that the defective fire barriers meant that a fire could spread from one floor to another. In doing so, the fire would consume the EPS insulation on each floor. But it's also worth noting another point, which arises out of the fact that the lack of a ribbon of adhesive around the EPS. And probably the best way to explain that is by reference to an email that was sent shortly after Grenfell, when these towers were first inspected. That's in the supplemental bundle, tab 3 at page 196. Email of the 25th of June 2017 from someone called John Powell at Frankham's.
Who are they?
I'm sorry, my lord?
Who are they?
I believe they were surveyors.
Right. And Hyde Housing?
Hyde Housing is the parent company of Martlet.
Okay. Right.
Sorry, Frankham's a risk management organisation. And if you can turn, please, to page 199. The third paragraph starts polystyrene foam.
Yeah.
And it says, polystyrene foam, like most organic materials, is combustible. However, its burning behaviour depends on the conditions under which it is used, as well as the inherent properties of the material. If EPS is exposed to temperatures above 212 degrees, it begins to soften, to contract, and finally to melt. Under certain fire conditions, EPS will ignite when exposed to an open flame. And then he says this, although foam insulation is relatively difficult to ignite, in the case of ignition, burning will readily spread over the exposed surface of the EPS, and it will continue to burn until all EPS is consumed. And if you turn over the page to page 200...
Just what do they mean by the Stowe decorative skin? The render?
The render, yes.
Yeah. It's horrifying how quickly it goes up, actually, because I remember doing a case years ago with this type of foam insulation, where a farmer had used it to insulate a barn in which he stored winter veg, and somebody inadvisedly allowed someone to use an angle grinder, and the sparks from the welder ignited the foam, and I remember seeing a demo of how this worked, and you actually had the sheet of foam on the side of the wall. And as soon as it took a long time for it to actually ignite, but when it ignited, it just went whoosh straight up the side of the wall. So, speaking for myself, I entirely understand why you need the barrier.
Yes, and so the paragraph that we've just looked at, what this is discussing is that the render stops any sort of fire or heat getting to it from the front face, from the front face of the insulation.
Yes, and then you've got the strip of mineral wool above it.
Above it, and then if we just come to what's behind it, over the next page at 200, at the very bottom, it says a further point to consider is the unprotected reverse side of the EPS insulation. As outlined above, the EPS boards are held in place by adhesive dabs and styro fasteners. The effect of these dabs is to raise the panels away from the surface of the original no-fine structure from anything up to 20 mils. This in effect creates a cavity behind the panels, a cavity where smoke and fire could travel, see below. This is exacerbated further at the base of the cladding, where there are visible voids beneath the panels, also poor detailing.
So this is effectively a cavity between the Stowe system and their structure.
The original structure, yes.
So you get oxygen in and whoosh again.
Yeah.
Yes.
Yep.
Now, just for your note, this report, sorry, forget that point. As we will see, this email is relied upon by Malali at paragraph 51 of their defence. We will look at that in due course, but you might want to note that now. 51 being the first paragraph referred to in my contingent plea at paragraph 41.6. So you see that the situation arising out of the presence of the combustible insulation is exacerbated because of the voids behind that insulation. Now, if we could go back to the pleading at paragraph 41.6, so that's your bundle tab 15, page 158. This is where we see the additional allegation relating to the selection and use of the EPS as insulation for the towers. Now, you've already seen that this is a contingent plea. That plea is contingent on Malali making out its defence that the losses claimed were caused by the fact that the insulation was EPS. Indeed, it's only if Malali's defence is made out that paragraph 41.6 is engaged. So in my submission, there can be no doubt when we think of Goode and Martin that paragraph 41.6 arises out of Malali's defence.
Because it's only if the defence is engaged.
Does it apply at all?
So you accept Mr. Hughes's point that it's contingent.
Yes.
In that sense, but you say it's contingent on the defence being right.
Yes.
Does it flow naturally?
Absolutely. If you're going to say why, can I come on to that? But
Well, I assumed you were going to say why. In due course, no doubt.
yes, I think I'm nearly there, but it certainly does flow naturally. It's easy for me to make that point
In your own time.
when we look at the defence, my lord.
Of course.
So, turning to the case which Martlet advances if the contingency arises, the clauses said to be breached, the clauses of the contract, are the same clauses we have seen at paragraph 41, save that there's now an additional reference to Regulation 7 of the building regulations. Then, just one point I'd like to dwell on that Mr. Hughes glossed over is the very end of 41.6. Before this meant that, because the fundamental allegation is that the EPS panels were flammable or combustible. And then when we come on to this meant that, it's pleading the consequences of the fact that we have combustible, or we had combustible EPS on the walls. First one, 41.6.1, is that the external walls do not adequately resist the spread of fire over the walls and from one building to another. Essentially, that is a breach, as expressly stated, of requirement B41 of the building regulations. And as we've seen, that's an allegation already made at paragraph 41.4 of the particulars.
Same breach, different reason.
Exactly. 41.6.2 is a short point about design life. Point 3 relates to unsuitability. And 41.6.4, unsuitable, well, install the system would not achieve a class 0 fire rating in respect to those areas of the towers above 18 metres. That arises out of the approved document relating to the building regulations. And you then get the plea at paragraph 41A, which I think the tribunal's already picked up on. It's not an essential plea to make good Martlet's cause of action, but what it says, it's worth remembering when considering whether paragraph 41.6 arises out of the same or substantially the same facts as the already pleaded case, because 41A demonstrates that the likely scope of additional investigation generated by paragraph 41.6 is nil or limited, because it's already Malali's case that the EPS did not comply with the building regulations in force in 2017. In terms of enquiry, compliance with those regulations already needs to be considered. And there has been no material change to those regulations between the date of the contract and 2017. My lords, we have building regulations in the bundle, the two relevant versions. In the core bundle, the 2000 version is at tab 19.
Yeah.
And it may just help if I show you the requirement that for these purposes there. So it's tab 19, page 325.
These are the regulations 2010.
No, these are the 2000 regulations.
2000.
So these are the contract.
Sorry.
Contract regulations.
So these are the contract regulations. On which page?
So actually, if you start with regulation 4, page 315. You see the point, paragraph, regulation 4.1, building work shall be carried out so that it complies with the applicable requirements contained in Schedule 1.
Yeah.
And if you turn over the page, you see regulation 7 that we've mentioned. And that's building work should be carried out with adequate and proper materials and in a workmanlike manner. Then when we come to the requirements, that's at page 325. And you see at the bottom B34 and B41.
And the requirements start
at page 324.
Yeah. And you want us to look at 325.
325 is where you see the pleaded requirement.
That's B3.
B3 brackets 4 and B4 brackets 1.
And those are the ones you've pleaded.
Yes.
Yeah.
And then at the next tab, tab 20, is the 2010 regulations, which were in force in 2017.
Got it.
And you'll see at 331, regulation 4 again.
Yeah.
There are subtle changes, but I don't think they make any difference for present purposes. You still have the requirement that building work should be carried out so it complies with Schedule 1. Regulation 7 is at page 333 and is the same. And the actual requirements are at page 356.
Any material change between B3? B3?
No material change at B34 or B41 are the same.
Yeah.
So then I come back to my case on causation and loss. So tab 15 of the core bundle, page 160. And you can see there's been no amendment to that section whatsoever. starting at paragraph 43.
Starting at paragraph 43.
Yeah. Okay. Yes.
Discovery of the defects and events thereafter.
Yes.
Right.
So there's no amendment to this section, but one point to note is paragraph 57, which is at page 163. And so this is telling the story of the Waking Watch. The Waking Watch, I don't know if you're familiar, but it's fire wardens, people who stand outside.
I worked out that's what it was, Mr. Selby.
Very good. I'll move on. But the point of paragraph 57 is that once the EPS insulation was removed from the walls of a tower, the Waking Watch was no longer required. That's what we plead on our.
And you pleaded it all the way through. No change.
No change to that. That's the original plea. Because that emphasises the role that the presence of the EPS plays on Martlet's originally pleaded case. Once the EPS was removed, there was no longer any fuel on the walls to feed any fire that might take place. In short, in my submission, the presence of combustible insulation on the walls has always been an integral feature of the pleaded claim.
Yeah.
So just to take stock of the amendment to the particulars of claim, I say no new duties alleged, no new case on causation or loss alleged, the only additional allegation pursued at all in the amended pleading is a contingent allegation. A contingent allegation that only arises if Malali's defence is made out. The additional allegation relates to the combustible nature of the insulation, but the combustible nature of the insulation is already integral to the original claim, because there are already pleaded issues about the manner in which that insulation has been fixed, in addition to the pleaded issues about the fire barriers which are supposed to contain any fire that may arise in the external walls. So I then come to the defence, which is at tab 16. And it's actually quite helpful or easy to start with the summary of Malali's case, starting at paragraph 7, which is at page 167. So you see at 7 they talk about the backdrop of the events of Grenfell Tower, and how Martlet procured investigations into the cladding works. Those investigations led Martlet to understand. And then you see at 7.3, the cladding works comprise external wall insulation with a render overcoat, and the EWI product, external wall insulation, used was the Stotherm Classic K system, which contained combustible insulation materials which complied with the building regulations in place at the time the works were carried out, but which did not comply with the building regulations current in 2017. So immediately you see there, 1, insulation is combustible. 2, the system complied with the building regulations in place at the time the works were carried out. And then you see at 8 how Martlet decided to instigate a waking watch, decided to remove the cladding work and replace it with EWI, which was non-flammable. I think they use the words non-flammable or flammable and combustible interchangeably. There are differences as a matter of fire engineering, but I don't think anything.
But we don't have to worry about that.
Turns on that for present purpose. And then they say in replacing the cladding works with external wall insulation, which was non-combustible, Martlet ensured, as it was obliged to, that it complied with the building regulations complied with the obligations under the regulatory reform order, and complied with the advice note 14. And then you see at 10, Martlet is not entitled to be compensated for matters which are outside Malali's scope of duty in any established breach. It's denied that Martlet is entitled to the costs and damages that it seeks, since first, any breach by Malali was not the cause, in fact or in law, of the losses claimed by Martlet. And then you see at 12, Malali admits certain workmanship defects specifically as set out below. However, Malali denies any workmanship defects were causative of the losses pleaded by Martlet. That's their case in summary. But if I may, I'll now take you through the key provisions, starting at paragraph 34 at page 172. So you've already seen some of this. Paragraph 34 at the top, you see the very first line, Malali denies any breach of its design obligations. And then you see at 35, Malali discharged its obligations in respect of the design of the works. I'm jumping through the clauses. In respect of the design of the work, in that it carried out the design of the cladding works with the reasonable skill and care of the appropriate standard. Again, a positive avowal of compliant design. And then it says, in carrying out its design, Malali, and my lord, you took Mr. Hughes to 35.1 of the new pleading. The original 35.1 is what's now 35.5 over the page. You see there, Malali relied on the British Board of Agrement certificate, the BBA certificate, to demonstrate compliance with the contract and building regulations in force at the time the contract was entered into. And you see at 35.6, which was 35.2, acted with reasonable skill and care of the appropriate standard in doing so. And then you see at 36, a positive case in relation to design life. Malali denies the alleged breach of GD 010 in respect to the assessed cladding design life of 70 years on the basis that the obligations relate only to the design Malali was to carry out. So that's a positive case on design in the original pleading. Then we see, I don't think we need to look at it in any detail, Malali pleads to the particulars relating to the fire barrier defects at paragraphs 38 to 41. But then if we go to 42.1, where they plead to the insulation defects, this is the point about the lack of the ribbon. You'll see here that they say Stowe agreed to the dot and dab application which was used to compensate for the uneven substrate which the continuous sausage was not suitable. And there's a request of further information relating to that plea which is worth noting. That's at tab 21. At page 361. Sorry, I should take you to the request first. At page 360. So it follows from request 5, where the request made was whether Malali admitted or denied that it was in breach of the contract in relation to the fixing of the insulation. And then request 6 is if Malali doesn't admit breach, please state its basis for doing so. The answer is over the page at 361. If I could just take you for present purposes to answer 6.2, where they say the specification for the Stowe cladding system included in Malali's contractor's proposals was developed with Stowe into a bespoke specification for Gosport Towers, and that was dated 21st of February. This document is silent on the pattern of adhesive to be used when installing the EPS boards. So we see very clearly here a positive case as to the specification for the system being developed between Mulalley and Stowe, specifically for these towers. That's a positive case in Mulally's original defence about how Mulally's design was developed. That case may have been in response to Martlet's case about the absence of the ribbon of adhesive around the EPS, but that doesn't get round the fact that the development of the specification for the system is already going to be investigated on the original trial, on the original claim. The specification is not described in the further information as a bespoke specification relating solely to the manner of fixing the EPS. It's described as a specification for the Stowe cladding system. And just to square off that point, if you go to the reply at tab 17, at page 227, you could go to paragraph 23.2.2 of the reply, please. Martlet pleads that it will say that the 21st of February 2005 specification was a defective design, as it should have specified the use of dowels of those specification. So the design is very clearly in issue on the current case, on the original case. And that's before we come on to the case, Mulally's case on causation. So if we go, just for the note, the case on causation is actually neatly summarised by the judge at paragraph 45 of his judgment. And just to develop the actual pleading at tab 16, page 189. So the starting point is paragraph 51. Mm-hmm. And this is the email I took you to about the EPA. Yep. On the 25th of June, Martlet was told by Frankham that the cladding works comprised a flammable, expanded polystyrene system, which in itself posed a fire risk and was not compliant with the building regulations current at the time. And then the paragraphs that I relied upon carry on to 55.
When you say the paragraphs you relied on, these are the ones that you identify in your amendments, yes. Because you say if, as alleged in paragraphs blah, then you say yes. It's a breach.
Yeah.
Okay. Well, we've looked at
exactly
those. You've identified those.
Yes. And in my submission, what you get from those paragraphs is that it's Mulally's case that the combustible nature of the EPS meant that the cladding system did not comply with the building regulations then in force in 2017, and that in order to comply with the regulatory reform order, the entire cladding system had to be removed and replaced.
No.
And what you one additional point, if you could turn please to paragraph 74 at page 194. You see at 74.1, they refer to a stew report which my clients obtained on the 4th of September 2017, and they positively plead that that report, and you'll see this at 74.1, confirmed that the stove-therm system used in the cladding works was permissible under the building regulations in force at the time the contract was entered into. So they're pleading evidence that the system that they installed complied with the building regulations as at the date of the contract. Advice note 14 comes later in the chronology. You see that at paragraph 84. But you see it, the plea at 84.2, which makes good my point, where they say that the advice contained in that advice note reinforced and clarified the existing government advice to ensure the safety of residents by removing any non-compliant cladding. Again, this advice arises only as a result of the nature of the EPS cladding and is not related to any defects which may be present in such a system. Nature of the EPS cladding, combustible nature of the EPS cladding. There's also a lengthy appendix to the defence, which is a detailed chronology. It essentially repeats the points made in the defence that the EPS was combustible and didn't comply with building regulations in 2017, and so the whole system had to be removed in order to comply with the RRO and Advice Note 14. I don't think the tribunal will thank me if I take you through that now, so I won't, but I'll leave it to you to peruse at your leisure if you think that's necessary. If I can just take stock of the defence, we see very clearly that in its original defence, Malali denied that it was in breach of its design obligations. It advanced a positive case as to how it developed its design and complied with its design obligations. Malali positively relies upon the combustible nature of the EPS and puts in issue the compliance of the EPS with the subsequent building regulations requirements, and pleads evidence that the system complied with the building regulations in force at the time of the contract. And it also contends that it's the combustible nature of the EPS and its non-compliance with subsequent building regulations requirements that gave rise to the remedial works.
Well, what was that last point again?
I'm sorry. The combustible nature of the EPS and its non-compliance with subsequent building regulation requirements gave rise to the remedial works.
Right. Yeah.
So let me come to my ground of appeal.
Yeah. Yeah.
Whether Martlet's EPS case is a new claim.
Yeah.
Now, in terms of the relevant law, my learned friend Mr. Hughes summarises the principles quite neatly at paragraph 11 of his supplemental skeleton argument. If I could ask you to turn to that, it's tab 11 at page 82.3.
The principles to be applied, yeah.
Yes. So I agree with those principles. I would only amplify Roman 2, where he says the court compares the essential factual allegations already pleaded with those proposed by way of amendment. He cites Co-op and Burst at paragraphs 20 to 21.
Mm-hmm.
If you could just turn those paragraphs up So that's authorities
Can
bundle.
you just tell us what the gloss is before we look at the paragraph?
Yes, of course. It's like the gloss is simply that in identifying a new cause of action, the bare minimum of essential facts abstracted from the original pleading is to be compared with the minimum as it would be constituted under the amended pleading.
Bare minimum compared with bare minimum.
Yes.
And what's the paragraph?
20 and 21.
Wants to look at that.
Well, I don't think you need to see it if you're willing to accept the proposition.
Well, I'm sure you're right in terms of the citation, but it's probably best just to...
Yes. So, tab 5.
20 and 21.
Bundle page 46. And you see almost exactly halfway down the first column, there's a reference, it starts in quotes. So in identifying a new cause of action, the bare minimum of essential facts abstracted from the original pleading is to be compared with the minimum as it would be constituted under the amended pleading. And then you see at 21, about 6 or 7 lines down after the Begum case, a change in the essential features of the factual basis, rather than, say, giving further particulars of existing allegations, will introduce a new cause of action.
Mm-hmm.
So that's what you're looking for when you're applying the new claim test.
Mm-hmm.
And if I can apply that test to the facts of this case, in my submission, the bare minimum of the essential facts abstracted from the original pleading is that the design and or construction of the external wall insulation system was such that the external walls of the Gosport Towers did not adequately resist the spread of fire.
So you say the bare minimum for the old pleading, the external walls, in short, the external walls did not adequately resist the spread of fire.
With the result that the whole system had to be removed and replaced with a non-combustible system. And in my submission, those remain the essential features of the factual basis of the amended pleading. And if I develop that by reference to what I've already said in my skeleton, same duties already pleaded are relied upon in the amended pleading. We don't assert any new duties. Same building regulation requirements are relied upon. Precisely the same loss and damage is pleaded in both. The new allegation relates to the same element of the building as the already pleaded breaches, the external walls. It also relates to the same part of the external walls as the already pleaded breaches, stow system. It relates to a component of the stow system that is already the subject of an already pleaded breach, the EPS.
Yeah.
It's a universal defect in both the original and the amended claim.
Meaning throughout all buildings.
Yes. Maybe I should say universal or systemic.
Mm-hmm.
The original claim already concerns both the stow system as a whole and its application throughout the external walls of each tower, and the performance of all elements of that system in the event of fire. and there's already a case that the EPS had to be removed in its entirety. On the originally pleaded case, all the cladding had to be removed, so the need to remove the EPS was always an issue. Now, I think what Mr. Hughes says is that I put my case at too high a level of generality. I disagree. I'm actually applying the test of how the cause of action is to be identified. Bare minimum of essential facts in the original and amended pleading. Not by descending into excessive levels of detail and particularity. The only additional allegation now being advanced is that the combustible nature of the EPS meant that it should not have been used in Malali's cladding system in the first place. But in my submission, that allegation is further particularity of a case that is already pleaded. That the external walls did not comply with requirement B41 of the building regulations. The external walls did not adequately resist the spread of fire.
Which one's that?
B41. And so I submit that the new allegation is not a new claim. I should just address why I say the learned judge fell into error.
Yeah.
That's paragraph 34 of his judgment. It's at tab 5 of the core bundle at page 43.
Yes.
And it's paragraph 34 of the judgment. Six lines down is the analysis. Here, the essential factual basis of the original design claim in respect to fire safety was that the efficacy of the fire barriers was compromised by air gaps and the use of inadequate fixings. By contrast, the essential factual basis of the proposed amendment is that the use of combustible EPS insulation boards was itself a breach of contract. That I am satisfied is a new cause of action. We submit that the judge fell into error here because he failed to take into account two matters.
He failed to
take into account two matters. First, that the original design claim in respect of fire safety also relates to the fixing of the EPS insulation boards. He just refers to the fire barriers. Secondly, that the EPS is part of a cladding system. The very purpose of the fire barriers is to stop fire spreading from one section of EPS to another section of EPS. As I've already said, the originally pleaded case is all about the ability of the external walls to adequately resist the spread of fire.
But if the case depended entirely on the use of combustible material as part of the cladding system, then it wouldn't matter how many fire barriers you had.
You're right. You're right. But
that's what makes it somewhat different, it seems to me. Yes, it's part of the cladding system, but you weren't complaining about that.
No.
Originally, you got a complaint that, bearing in mind that you've got combustible material, there are mitigating factors that are put in place. One of which is this layer of the barrier, the wall. Then you've got the render. Then you've also got the fact that you should be adhering the adhesive, and that's all defective because there are gaps behind it which allow the air to get in, etc., etc. Now, all of those points can be made, notwithstanding that the material's combustible. The focus now is on the combustible nature of the material and the fact that however well you design the system, it's going to go up as soon as it catches fire.
Yes. But in my submission, that's still just further particulars of the overriding
I see the way you put it.
argument, but it doesn't adequately resist the spread of fire.
Could you just run past me again the second reason why the judge was wrong? The first was the original design
Related to the fixing of the
and the
insulation.
second one was
That the EPS is part of a system.
right.
The point is being presumably that the complaint really is about the inadequacy of the system as a whole, and this is just one element of it.
Yes.
That's the argument.
Yes. Excuse me. And in my submission, that the learned judge failed to take into account the second point is apparent from what he later states at paragraph 36 of the judgment, where you see at the end of line 4, the original particulars of claim was simply not concerned with the use of combustible EPS insulation boards.
Sorry, go to where?
Paragraph 36 of his judgment.
Well, that is actually my lady's point, isn't it, that she's just put to you?
That, well, except I read
Thought, I mean, not as well put, of course.
couldn't possibly
Very well put by
couldn't possibly be. But I read it differently in my submission.
Is it?
I understand this paragraphs 34 and 36 as saying essentially that the originally pleaded claim wasn't concerned about the EPS at all.
Use.
Well,
It does say with the use.
yeah.
Anyway.
I think the judge is saying the complaint isn't about the fact that you've used combustible materials.
My lady, the reason why I disagree is more back to 34 where it doesn't refer to that.
Yeah.
Yeah, that sentence isn't actually his decision, is it?
No.
It's just a.
Further.
He's moved on. He's moved on from the new claim
Yes.
point
Yeah.
at this point. He's just using it as a reference point, as it were, in deciding stage 3.
So you're either right about 34 or you're wrong.
I'm absolutely, my lady. And we won't call the judge to give evidence. Now, just to finish off my ground of appeal, I should address Mr. Hughes's point that paragraph 41.6 is a contingent plea, therefore it must be a new claim. I don't follow why the fact that it's put on a contingent basis makes it a new claim. In my submission, one doesn't follow the other as a matter of logic.
Okay, so is that your
Second
case on the respondent's notice?
Yes. So I now come to my final topic, which is same or substantially the same facts.
Yeah.
And I'll address ground 1 first, the Goode and Martin point.
Well, in a sense, in terms of the grounds, I mean, don't necessarily feel constrained by that because the first 3, in one way or another, are Goode and Martin points.
They are, but ground 1 is a point about the proper
Interpretation
scope.
of Goode and Martin.
Exactly. So
And then 2 and 3 are.
application.
Yeah. Okay. All right. Well, in fact, by all means.
Thank you. So I had 2 broad submissions on ground 1.
Mm-hmm.
First, Malali's case is not supported by the language of CPR Rule 17.4 itself. Secondly, it's not supported by the authorities. So, dealing with my first point, it probably helps to get the rule out, which is at tab 2 of the authorities bundle. In my submission, 2 aspects of the language are relevant. The first aspect is the obvious one. The rule says the same or substantially the same fact. It means what it says.
Yeah.
If no new facts could be introduced, it would not say or substantially the same facts in the rule itself. You would have to put a line through them.
Yeah.
My second point is that the test is whether the new claim arises out of the same or substantially the same facts. In my submission, a new claim can arise out of the same or substantially the same facts while also introducing new facts. If I can illustrate that point by reference to the facts of Goode and Martin. So if the defendant's defence was that the claimant sustained her injuries because she stood up in the yacht during the course of the jibe, it would be open to the claimant in my submission to amend her particulars of claim to allege that the defendant was negligent because he never gave her a proper safety briefing before she set sail. And within that said, you should always stay sitting in your seat. That would be a new claim arising out of the same or substantially the same facts. But it would introduce...
One of the facts is that she got up.
The fact is that she got up, but it does introduce a new fact, which is the defendant's failure to give an adequate safety briefing.
But it's founded on the fact that she got up, and there are consequences that flow from that.
Yes. And in my submission, to amend the particulars of claim to make such an allegation should still not be objectionable.
Well, what the rule doesn't say is if the new claim does arise out of the same or substantially the same facts, you can't make it good by referring to other facts.
Yeah.
Which, to me at least, seems to make a certain degree of sense, because if you read the Goode case as narrowly as Mr. Hughes would have us read it, it means that you could virtually never be able to argue the reason why what you're now alleging was a breach. So you get Lord Justice Sales's analysis. You must be entitled to say, well, if what you make out in your defence is correct, you were also liable. And you can't just stop short on you were also liable because of what you've alleged in your defence. As you point out, the defendant's never going to say, well, I was negligent in that respect, so you've got to be able to put the essentials as to why. Yeah. And it's a question of fact and degree whether you trespass beyond what is permissible to show that it arises out of the same facts. Yes.
On that trespass point, I wonder if I could give you another illustration about where you might come to when you're trespassing. If we use the facts of my case, if I had amended my pleading and not just said the use of combustible EPS is your fault, but if I had amended my pleading and said, oh, and in any event, the cladding had to come off because it was leaky and there was water coming in, then you've got a different situation that you might well say you're not pleading a case that is arising out of the defence. Maybe not, but it's a different set of facts. So that's not what we do in this case. And then moving on to the authorities, the starting point is Brickfield.
When you say moving on to the authorities, under
this issue. So I said one, Mr. Hughes' argument is wrong on the language of the relevant.
Yeah, I understand that, and you say, and it's wrong.
It's not supported by the authorities.
It's not supported by Goode and Martin.
It's not supported by Goode and Martin or any of the other authorities.
All right, so you're coming to other authorities, but under ground one.
Yes. The starting point is Brickfield, which is at tab 3 of the authorities bundle. Now that obviously.
Ground one is the judge wrongly interpreted Goode and Martin.
Yes. You're right, my lord. But if I could just take
Brickfield and Newton.
It's
decided many years before
on the old rules, but it's the same language.
Well, I'm sure, but
Yeah.
that doesn't arise out of the defence, for example.
No, but it does say very clearly.
I mean, but by all means, come to them. What I'm really doing is querying whether, in fact, on analysis, a case like Brickfield and Newton arises on Mr. Hughes's ground 1 as opposed to his grounds 2 and 3. But that's a matter for wrestling with the judgments in the weeks to come.
Quite possibly. If you could
just as long as you've made your submissions, it won't matter.
I've got it. If you could just humour me, that might be the quickest way.
Fine. Okay, so Brickfield and Newton.
At page 23.
Yeah.
Sorry, bundle page 23. The sideline passage, halfway down the page.
Do we need to worry about what the rules of the Supreme Court said, the wordings?
No.
Rule 5.5 is pretty much the same wording. If I can find it for you if you want me to.
No, I only asked if I had to worry about it.
The answer is no.
Same or substantially
It's the same.
But you see there.
No, those are the words.
Lord Justice Cross said, no objection to amendment under Order 20 Rule 5.5 that some of the facts out of which the new cause of action arises are peculiar to it, and that some of the facts out of which the old cause of action arises are peculiar to it. It's enough if the overlap is so great that the new cause of action can fairly be said to arise out of substantially the same facts as the old cause of action.
Yeah.
So that's the point about you can introduce extra facts.
Exactly. So, but then turning to Goode and Martin,
Yeah.
what Malali seek to argue is about what Goode and Martin actually decided. And in my submission, the ratio of Goode and Martin is at paragraphs 46 and 47, and that's tab 4, page 37 of the authorities. And the ratio is that you can read in to Rule 17.42 the words are already in issue on. That's it. That's the ratio. And the reference to no new facts, that comes earlier at paragraph 42. I remember Mr. Hughes took you to that. But in my submission, the introduction of no new facts is not a prerequisite of obtaining permission to amend.
Well, it's almost part of the reasoning as to why in that particular case she was allowed to add the claim in the present action to the alternative plea. In other words, I don't see any reason why she shouldn't be allowed to allow it, says the judge, because no new facts are being introduced.
Yes. And there's not actually a stated issue as to whether, if you can look at the defence, whether the new claim arises out of the same or substantially the same facts. The only issue before the court was, can you look at the defence?
The phrase substantially the same implies there are new facts, doesn't it?
That's my point. Yes. Yes.
So you say the issue in Goode and Martin is whether you can look at the defence?
Yes. And you've also seen paragraph 36.
Yeah, that's the flow naturally.
The flow naturally. So it's put slightly differently there. Does the amended pleading flow naturally from the defence? Which is actually more consistent with the ratio. I'm not sure if you need me to take you to these authorities, but the subsequent authorities do record the ratio in the way I have said by reference to paragraphs 46 and 47. The Libyan investment case in King, that quotes the ratio at paragraphs 38 and 39.
That's Lord Justice Nugent, isn't it?
Yes, tab 11, page 181. Yes.
Do the other judges deal with this point?
I think they agreed with.
They agree with him. They disagree with him on another point. Don't they?
Yes.
Do they actually expand upon it?
I don't. I can't. To be honest, I can't answer that question. My recollection is where the judges differed was on whether or not permission should be granted to amend the judge's order under the slip rule.
Okay.
Not to do with the test under 17.
Yeah, you're right. That's what it is.
But you even see it, paragraph 38, so page 181 of the bundle.
Yeah.
At the very bottom, where he's referred to Goode and Martlet, paragraph 38. The actual decision of the court was that CPR Rule 17.42 should be interpreted as if it read.
Yes.
And then you see it over the page. And then he even says, that's part of the ratio and hence binding on us. See Ackers and Samba Financial, where Pepperall J.
And this all mattered for that case because they're looking at what was then in issue, but can't be done by looking at facts that were previous in issue but are no longer in issue. That was what mattered in Libyan investment.
Yes, because the particulars of claim in that case have been completely struck out.
Yeah. Yep.
The other judges don't say anything, as far as I can see. They just agree with him, and then on that point, and then disagree with him on that point.
That was certainly my recollection, but I didn't want to assert.
Okay, so you say that's the ratio,
Yes.
and you rely on Libyan, and this Ackers seems to say the same thing.
Yes, it's
as recorded by Lord Justice Nugent.
Yes. And just for your notice, it's paragraph 24 of Ackers, and that's tab 9, page 116.
Yeah.
And that ratio is consistent with the purpose of section 35.5 of the Limitation Act, as summarised by Lord Justice Tomlinson in Bollinger and Mercer. And I think it's the one bit that Mr. Hughes didn't take you to, so maybe we should deal with that now. So it's tab 7 of the authority bundle at page 85.
Yeah.
It's where actually Lord Justice Tomlinson quotes from Mr. Justice Coleman's decision in BP and Aon, and it's those paragraphs 52, 53, and 54. Purpose is to avoid placing a defendant in the position where, if the amendment is allowed, he will be obliged, after expiration of the limitation period, to investigate facts and obtain evidence of matters which are completely outside the ambit of and unrelated to those facts which he could reasonably be assumed to have investigated for the purposes of defending the unamended claim. And then 53 quotes Lloyds Bank and Rogers, which you see in a number of the cases. Policy of the section was that if factual issues were in any event going to be litigated between the parties should be able to rely on any cause of action which substantially arises from those facts. And then 54, the substance of the purpose of the exception is thus based on the assumption that the party against whom the proposed amendment is directed will not be prejudiced because that party will, for the purposes of the pre-existing matters in issue, already have had to investigate the same or substantially the same facts. So the policy, as summarised, doesn't preclude any new facts being pleaded in the amended particulars of claim. It all comes back to substantially the same.
well, as I said, it's a question of fact and degree, because if you're looking at the policy behind it, if the party who would otherwise be entitled to rely on the time bar has to carry out a whole new investigation of extra facts, then that might be said that you moved the wrong side of the line.
Yeah.
You say that's not this case. You say this case is sufficiently causally connected with what was already an issue, because the overarching complaint was about the combustible nature of the external wall.
I say that in relation to my particular claim.
Yes.
But if you don't accept that on the particular claim, it certainly comes out of the defence.
Yes.
The word substantially protects the defendant.
Yes.
That I followed that submission. Just looking at it, paragraph 52 is slightly odd because, in paragraph 34, it says helpful guidance, and then that's the first paragraph. 52 is from Mr. Justice Coleman, and he says, at first instance in Goode and Martin, I said,
yes,
because he was overturned. Because Goode and Martin, the Court of Appeal allowed the amendments, Mr. Justice Coleman hadn't.
yes.
And also, it might be said, and this is always the danger of these things, and glosses, it might be said that which are completely outside the ambit of and unrelated to those facts might be regarded as putting it a tad high.
My lord, I'm going. There's 2 points on that. The first is Mr. Justice Coleman was overturned because he felt he couldn't look at the defence.
Okay, fine, I understand
so
that.
it's different points.
All right.
The second point, which is the glosses and so on, you've picked up on a point that was also made in Libyan Investments. So maybe I should take you back to that.
Okay.
It's at page 185 behind tab 11.
Wait a minute now. I've got to go. So this is 34 of Ballinger.
Yeah.
Citing Goode.
First instance.
Thank you. Does it overstate the case? Libyan Investments, tab 11, page
185.
Yeah.
Paragraphs 49 and 50, where Lord Justice Nugent actually said, I don't think it's necessary or helpful to seek to resolve the slight difference between these statements of policy. In any event, as both counsel accepted, judicial statements of the policy behind the Act and the rule necessarily at a high level of abstraction are not and could not be a substitute for applying the wording of the provisions. Right. And then you see paragraph 50, I see no value in attempting to or reconcile the slightly differing expressions of policy by Coleman J and Hobhouse LJ. The general sense is clear enough that an amendment can be allowed to plead a new cause of action if the underlying facts are already the subject of the proceedings, but this cannot determine the question of how the rule is to be applied. It's the very unusual facts of that case. So it all comes back to the language.
So ignore gloss is go to words. Sound advice.
Now, my learned friend relies on the
Yes.
My learned friend relies on MasterCard, the judgment of Lord Justice Sales. So that's tab 8. And the first point to note is at page 103 of the bundle.
Yeah.
Where you see at paragraph 41 that Lord Justice Sales correctly recorded the ratio of Goode and Martin.
Yeah.
The reference to no new facts follows at paragraph 42. but of course, Lord Justice Sales not there stating that it's a precondition to the applicability of Goode and Martin that no new facts are required to make out the amended claim.
Yes. He's giving it as an example. In such a case, the defendant has chosen to put those facts in issue.
Yeah. And you see at 43, he then says, this sets the context for examination whether Mr. Justice Barding was correct in his assessment at first instance. And when you then get into the analysis of the facts, you see at 46 and 47, Lord Justice Sales was pointing out that the factual inquiries are radically different and so on. So that
this has certainly been an area of practice and procedure where this court, somewhat unusually, has not been shy of interfering with the judgments below. Most of these seem to involve this court coming to a different view to the first instance judge.
My lord, that's right, but there is a point actually on that in MasterCard, which I should actually, I might as well deal with that now.
Well, we're in it, so yeah.
I'm sorry, my lord?
We're in it,
Yes,
so yeah.
yes, exactly. And if you could turn back to page 101.
Yeah.
Just for your note, is paragraph 35 of Lord Justice Sales' judgment. But can you, about 10 lines up from the end of that paragraph 35, he starts, in some cases.
Mm-hmm.
He says there, in terms of whether permission to amend should be granted, that may involve an evaluative judgment by the court, in which it's possible to say that there is more than one answer which could rationally be given on the point, and in relation to which it could not be said, should any of those answers on appeal, that it is wrong, such that an appeal should be allowed. In other cases, the issue may be more clear-cut and admit of a single answer which is right, so that if a different answer is given by a judge, it can readily be seen on appeal to be wrong. In both sorts of cases, it's strictly a matter of analysis, whether the judge has made the proper or an acceptable evaluation on the question, whether the condition has been satisfied. So you can see that yes, the court has been willing to interfere with the decision of the judge at first instance. But it's very clear only where it's clear that the judge's evaluation doesn't stand up.
Yeah.
The final authority relied upon on ground 1 by Mr. Hughes was the Hyde and Nigate decision of Mr. Kimball QC at tab 10.
Well, we only looked at that to see how the underlining of the word any.
Yes, if I could just, my headline is Hyde and Nigate doesn't take it any further.
All right, well, to the extent that Mr. Hughes took it further, it was only a few inches.
Yes, well,
So,
if I could just make my point very quickly.
yeah, I'm just anxious that it's 20 past 3, gone 20 past 3, and you haven't dealt with grounds 2 and 3, which I regard as key to this appeal. I don't regard ground 1 as key to this appeal, as I hope I've made plain.
So my only point is, at paragraph 30 it starts, the 4 points which I derived from MasterCard are as follows. So all Mr. Kimball was trying to do was summarise points arising from MasterCard. He wasn't trying to take the law any further.
Yeah.
That takes me on to grounds 2 to 4. You've got my submissions on Goode and Martin and the underlying policy. If I could just add some other propositions. At this stage of the analysis, the court is concerned with all the evidence likely to be adduced at trial.
Mm-hmm.
See Co-op and Burst, paragraph 28. As Mr. Hughes said to you in his submissions, what the court has to consider is the extent to which the defendant would be required by the new claim to embark on an investigation of facts which the defendant would not previously have been concerned to investigate. Although it's been said that the issue is essentially a matter of impression, Well, that might be so in borderline cases. In others, it must be a question of analysis. So that's paragraphs 35, 36, and 38 of Bollinger and Mercer. You see. So, submissions on grounds 2 to 4 are as follows. The EPS case is not a wholly new cause of action. Second, it arises out of Mulalley's defence. Thirdly, the authorities that Mr. Hughes seeks to rely upon as essentially parallels on the facts aren't such. So in terms of the EPS case not being a wholly new cause of action...
Well, you've made your submissions on that.
I've made those submissions on that by reference to my pleading. They're equally applicable to this.
Yeah, I was going to say, if you were wrong about whether it's a new claim, you rely on all of the same submissions that you made to say that, to bolster the same or substantially the same.
Yes, but if I could, I've got some additional points to make.
Right.
So when I took you to the pleading, you'll remember I emphasised at 41.6, the end of it, that the fundamental allegation is that the EPS is flammable or combustible. And you've seen multiple references to that allegation in the defence.
Yeah.
Then, if you remember the 4 subparagraphs to 41.6, first was that the external walls do not comply with building regulation requirement B1. And as I showed you, that's already an allegation in the original claim.
But you've made these submissions,
Yes.
haven't you?
Yes.
The shortcut I was offering you is that all of the submissions you've already made about why this isn't a new cause of action apply again if you're wrong and it is a new cause of action.
Yes.
And you say that then it arises out of the same or substantially the same facts and matters.
Yes.
So the EPS being combustible, and you say, and that's pleaded ad nauseam in the defence, is therefore part of that, isn't it?
Well, I have to be careful, my lord, because when you're looking at whether it's a new claim for the purposes of my additional ground, the cases suggest that all you look at is the original particulars of claim and the amended particulars of claim.
Bare minimum versus bare minimum.
Bare minimum, and could well be said, probably do say, I can't look at the defence for that purpose.
Yes.
So you're right, my lord. I have taken you to the defence, but not in the context of my of the submissions on new claim. That was on my tour of the defence, tour of the pleadings.
So you're identifying additional paragraphs in the defence. You've actually already identified them.
Some I have identified. There will be additional points that I'd like to make in the defence, if I can, without incurring the wrath of the court. And maybe some I just deal with by notes because you will have seen them already. So you've already seen my particulars. You've also seen Malali's plea at paragraph 74.1 of their defence that there was evidence at the evidence that the system installed complied with the requirements at the time. That's already an issue. The point about design life, you've seen it in the particulars of claim, and you also saw paragraph 26 of the defence where they pleaded a case on design life. If I may, can I just give you one more reference to the defence, and that's paragraph 36 of the defence, core bundle, tab 16. Page 173. And you see there, I think you've actually seen it already. Malali denies alleged breach in respect to the assessed cladding design life. So it's the cladding as a whole.
Sorry, give me the page again.
Page 173.
Yeah. Paragraph
36.
First sentence.
So the design life is already an issue by reference to the system, not just the individual components. And then you'll remember the other two sub-paragraphs of my pleading at 41.6. Where do we see reference to that in the defence? Starting points 55.3. I know you have looked at these, but perhaps not with this focus. 55.3 at page 190. You see, Dother's system, which comprises cladding works, is no longer certified for use on buildings over 18 metres. And you see that again at 56. And then at 73.1.1 at page 193.
paragraph 71.
No, 73.1.1. Again, Stowe at the end of that subparagraph, Stowe's system not tested in accordance with British standards, didn't have a BVA certificate for use on buildings over 18 metres. And finally at 93.6, at page 199, cladding works comprise a system which was no longer certified for buildings over 18 metres in height. So this is all their case, which I effectively cite back at them at my 41.6.3 and 41.6.4. And so I say that the allegations in paragraph 41.6 very much arise out of the same facts or substantially the same facts. And the real question is, what are the differences between what's in issue on the original claim and what's in issue on the amended claim? From what I've heard, only two have been identified. The first is that Mr. Hughes's defence focuses on compliance post-Grenfell, whereas the amended claim turns on compliance at the date of the contract. But I've already shown you that compliance with the building regulations at the date of the contract is already an issue, as per not just my amended pleading, but also the defence itself. In any event...
Hang on.
I'm sorry, my lord.
So what was in issue at the time? Sorry. Yeah, what the situation was at the time of the contract, you say is put in issue in the defence.
Yes.
Yeah, and what was the next point?
There shouldn't be much difference between compliance at the date of the contract and compliance in 2017, because the building regulation requirements, as we have seen, never changed.
Mm-hmm.
Then the second difference between the original claim, the second difference between the what's in issue on the original claim and what's in issue on the amended claim is that Mr. Hughes contends that the amended claim now requires an investigation as to whether or not Malali exercised reasonable care and skill in its design. And as I submitted when I took you through the pleadings, Mr. Hughes is overplaying the reasonable care and skill point, because there are multiple obligations within the contract that do not turn on whether or not Malali exercised reasonable care and skill.
That's the strict liability one.
Yes. So the investigation is not required at all. In any event, as I've already said, whether Malali exercised reasonable care and skill in its design has always been an issue. I've taken you to a number of references, but can I give you, please, one more just to really ram this point home? If we could go back to the defence at page 172 of the bundle. Sorry, 173. You'll remember at the top, I took you to that paragraph how Malali pleaded that they relied on the BBA certificate. So that's their defence on the original claim. And what you've got is their amended claim now. And if you could turn through to page 184, at paragraph 42.35, you see the same defence. In selecting the Stotherm system, Malali and/or BPTW, the architect, reviewed its BBA certificate. The relevant BBA certificate for the system was carried out as the 95 BBA certificate. And they make that point again at 42.39 over the page. So actually their defence is the same on the original claim as the amended claim. Now I was also going to refer to the adjudication to show how the case can play out, because what you're looking at is all the issues that will become available, that will be raised at trial. And I was going to rely on the adjudication to demonstrate how almost a dry run of the original claim yielded.
But why has that got anything to do with the issue before us?
Well, you may say it's not, but normally what happens is the court is making its own evaluation of how things will play out by reference to the pleadings.
Well, you're looking at what was pleaded and the bare minimum.
Yes.
Comparing the two bare minimums.
So that's for new claim, but for substantially the same facts, you've got a broader...
Yes, but you're still looking within the confines of the pleadings.
Yes, yes.
And what is in issue.
Yes. So my only point by reference to the adjudication was that the adjudication was a dry run of the original claim, and an issue that came out in the adjudication was whether the selection of the EPS was compliant with reasonable skill and care, even on the original claim. Right. But if that doesn't assist the court, I understand that. And
in my view, it doesn't, because I think I just don't think overlaying this with, as it were, actual or constructed knowledge is going to help.
No, no. Right, so then I do have one more point. What is the story on the design process? Because Mr. Hughes engages some hyperbole about entirely new and you know, the juggernaut of new facts and so on its way. But actually, if you look at what they plead about the story of the design, it's very limited, and that's at paragraph 42.28 of the defence at page 180. You see at 42.28 they talk about a meeting on the 14th of February with the architect to commence discussion about design. And then over the page at 4229, they talk about a meeting with the architect and the subcontractor to discuss the cladding system and how the system was agreed at that meeting. And then at 42.30, they talk about the production of revised drawings. That's it.
So what do we get from that?
Well, what are what's the additional factual inquiry? It's that limited factual inquiry about three meetings, and also the production of the stove specification that we looked at when we looked at the further information of the defence. In my submission, that's quite a limited factual story, even if it is a newly introduced story. And that's not surprising in my submission, given that this is not a bespoke system, but effectively an off-the-shelf product. So that's what I say about new design. Is the design case new, and does it introduce new matters? Then the next ground, or the next argument raised by my learned friends, is that the EPS case, he says, doesn't arise out of Mulalley's defence. I've obviously shown you all the pleading references to that. In my submission, it's overwhelmingly clear that the amended claim does arise out of Mulalley's defence. Malali cannot validly contend that their causation case is simply all about compliance with the RRO or Advice Note 14, because on Mulalley's own pleaded case, it's the presence of combustible EPS that engages the RRO and Advice Note 14. We say that the amended pleading naturally flows in the way that the defence has been put. If the defence is that Martlet carried out the remedial works because the external wall system contained combustible EPS, what could be more natural than to say that Malali should not have chosen EPS in the first place? I think, as my lady said in one of her interventions, the defence presupposes that Malali is not liable in relation to the selection of EPS, and that is ultimately the point. Almost the point behind Goode and Martin.
The defendant wasn't pleading, here's my version of events and therefore I'm liable.
No.
The defendant was, in Goode and Martin, was saying, here's my version of events, and that's and I say that's a defence.
Yes.
And the claimant said, well, on that basis, if that's what happened, you're still liable because.
But in saying I say that's a defence, it must be implicit within that assertion that defence means I'm not liable.
Well, yeah. I'm not liable for the. I'm not liable in the way in which you have alleged in your particulars of claim that I'm liable.
Yeah. But yes.
So it does, to an extent, become circular. But the point you've got is that it is, you say, very close to the situation that Lord Justice Sales had in mind, which is, here's a reason why I'm not liable. Oh, yes, you are, because even if everything you say is right, one of the things you said is that this cladding is defective, and that's down to you and not down to us.
Yes, exactly. And you even see that point in MasterCard, as it happens, because it refers to another decision in a case called Goode, and that's sorry, I can give you a reference. Can I just have a minute to give you that reference? I'm sorry.
It's on 105, isn't it? of the authorities bundle, which talks about
Yes, it
laws of
starts.
sales, is it?
Yes, it
55,
starts at 105.
105.
It's paragraphs 56 and 57.
So which part of Goode do you rely on?
So, if we could start at 56, where they summarise, where Lord Justice Sales summarises the facts of Goode, and it was a claim against defendant lawyers in respect of advice received in relation to an investment, and they said that the advice was not in conformity with Russian privatisation legislation, with a subsidiary reason at first instance being the investment had not been cleared with the Russian competition authorities. And then the claimant pleaded that the first point could have been circumvented, proper advice been given. As regards the second point, the lower instance court decisions were wrong to say the investment required clearance. So this point had in fact no impact on the chain of causation flowing from the alleged negligent advice. Then the defendant, Goode, pleaded that the investment did require clearance, which was not forthcoming, and that this broke the chain of causation. And then in reply, the claimant pleaded that such clearance was not required, but if it was required, the failure to obtain it was also due to the defendant's negligence. And then you see at 57, the ratio of the decision is that this was permissible because IML was not relying on this allegation as a cause of action itself, but in order to counter Goode's argument that there was a break in the chain of causation, which was a cause of action, and then you see over the page, not unfair to apply such a principle. Damages will flow from the original act of negligence, and it talks about not being allowed to rely on their own wrongs and so on.
Yeah.
So that's that point. So I was just going to deal finally with the two parallels that my learned friend sought to draw in his oral submissions. First was the parallel with Co-op and Burse, and the second was the parallel with the Ackers decision. In my submission, neither are fair parallels with this case. Starting with Co-op and Burse, I say this case is not on all fours with Co-op and Burse, because in Co-op and Burse, localised defects were alleged in the floor slabs in the original claim. Those localised defects have given rise to existing damage, essentially cracking, that required localised remedial works. And that damage had occurred even though the full contractually specified racking load had not yet been applied to the floors. That was the original claim. The new claim alleged the presence of a single defect throughout the entirety of the slabs, which would give rise to future damage, not the present damage, if the contractually specified racking load were ever applied to the floors. And that new claim required a completely different remedial scheme, namely the complete replacement of the floor, not localised repairs. There was also an investigation required about the extent to which the floor slabs contained sufficient steel fibre, and you saw that at page 392 of the judgment, column 1, paragraph 2. The claimant in that case relied upon a particular and specific facet of the contractual duty of which no breach had previously been asserted. In essence, the original defects were no longer relevant, and the new claim arose out of investigations concerning the existing claim. And most importantly, perhaps, the new claim did not arise out of how the defendants had put their defence.
Well, you say most importantly for this case.
For this case, yes.
I mean, how people put defences doesn't often arise in relation to the same or substantially the same facts and matters.
Okay.
It's just a point here,
Yes.
and there was a point in Goode and Martin and one or two of the other cases that we've been shown.
Yes.
I mean, the other thing about bursts is that it's that the analysis is all to do with new cause of action.
Yes. And that was the curiosity of bursts. The judge found a new cause of action.
But then found that
Not the
it's
same or
not the
substantially
same.
the same.
No, quite.
And you saw Lord Justice Tomlinson in his summary of the law saying a new cause of action will likely, I might put it the wrong way around. It won't be a new cause of action. It will be a new cause of action if it doesn't arise out of the same or substantially the same facts.
Yeah.
I think I've got that the right way.
Yes, he put it the way that one would normally, the opposite way from the way in which you normally make the inquiry.
Yeah.
Which I thought was rather putting the cart before the horse, but still.
Then Mr. Hughes relied on the Samba Financial case, which is tab 9 of your authority. But again,
Hackers.
hackers, yes. But that again is just a completely different set of facts. It's a case where claimants originally contended that shares held by Mr. Al-Sinir on trust for them had been transferred by Mr. Al-Sinir to the defendant in breach of that trust. And because the claimants were in liquidation at the time of the transfer, they sought a declaration that the transfer was void, having been made in breach of trust. That claim was made under Section 127 of the Insolvency Act. And what happened was it went all the way to the Supreme Court on all sorts of issues. And the Supreme Court came out from nowhere, I think it was Lord Sumption, with a point that the claim was bound to fail because there was no disposition of the shares within the meaning of the Act, the Insolvency Act. And what the Supreme Court then did was remit the claim to the High Court to allow the claimants the opportunity to seek to re-amend their claim. And it was at that point that the claimants re-amended their claim by completely deleting their claim under the Act and alleging that the defendant held the shares as constructive trustee for the claimants. And what you get at 44 to 50 is the discussion by Lord Justice McComb. Sorry, McComb.
It's on live stream.
It's on live stream, and he may very well be watching for just that sort of point. Paragraph.
And he was a great judge in one of my cases, so I'm very sorry, my lord.
Yes.
Yes.
And you're about to cite him
Yes.
and rely on him.
Lord Justice McComb.
Yes. Yes. Paragraph.
And what he was looking at was what can I take into account? But you see at 44, the new claim is based on allegations of knowledge to be inferred from a multitude of facts said to have been known and of a plethora of sources of inquiry that is said ought to have been undertaken over a very lengthy period indeed. A claim made against a Saudi Arabian company in respect of shares in other companies traded on the Saudi stock market. What's to be taken to be known by Samba in that context and what inquiries it ought to have made must be extremely fact sensitive and very sensitive to the legal and commercial context of the disputed transfer. So this was knowledge of the defendant in relation to the transfer of the shares and what should be inferred in relation to that knowledge to make that defendant a constructive trustee. And
So this is another case where the Court of Appeal changed the result.
yes, but then when looking at the fact,
Yeah, I mean, you say this is completely different
yes,
on the fact.
but it also had the quirk that there was no originally pleaded claim still live that they could look at.
Because they deleted
It had all been deleted.
Yeah.
So there was nothing, and so what they were looking at was just bare assertions in skeletons or whatever,
Yeah.
where it was said, my clients acted in good faith. That was it. So I think I've heard this court say before, all these cases turn on the facts, But this case is certainly not one that you can rely on as a parallel. And you see it in it's essentially about bad faith, which of course the courts always said is a new claim.
Okay.
So that's my submission on ACCAs. And my lords, I think I've covered everything. If there's anything I've not covered or I can help you further with.
I was just looking at your 3 points, not holding a new cause of action, rises out of Mulalley's defence, and your third point was why his authorities aren't parallels.
Yeah.
So, yeah, well, I haven't got anything.
No,
No, thank you very much.
Thank you.
Mr. Selby. Mr. Hughes, any reply?
My lords, my lady, very briefly in reply, and I'm mindful of the time.
Don't worry about that. I mean, it's
well.
I think we've trampled the ground pretty thoroughly. But anything you've got in reply,
Certainly,
by all means.
the ground feels solid beneath one's feet, well trampled. First point, really, the building regulations. It's been said, well, they didn't change, and they constitute forms of strict liability. But just to look at them very briefly, and then look at my consequential amendment to the amendment that is disputed, of course, on this appeal. Could you go, please, to tab 19 of the core bundle? See core bundle 324. So 324 is Schedule 1 requirements, to which Fernando Friend's taken you to already. Over the page, B34, towards the bottom, 325, the building should be designed and constructed so that the unseen spread of fire and smoke in concealed spaces in its structure and fabricators is inhibited. And then B41, the external walls of the building shall adequately resist the spread of fire over the walls and from one building to another, having regard to the height, use and position of the buildings. And my lords, my lady, you have seen that language does not substantially change in the 2010 building regulations. But the significant point here is adequately resist the spread of fire. It is not, in and of itself, hard-edged. And that takes me then back to my amended defence responsive to this amendment. And if I could go to tab 16 of the defence, this is core bundle 177. But the point I wish to make in reply is that my learned friend says, well, it's all building regulations, they were pleaded before, they were pleaded later, nothing changes, and so the investigation and inquiry under the original plea and the amended plea is substantially the same.
Adequacy is a matter of fact and degree, you're going to say, and it's a matter of opinion.
Well, there's certainly that, my lady, but there is also temporal component, and we pick that up in the amended defence at 42.13, CB 177.
Yeah.
As at the 20th of January 2005, so January 2005 was when the building contract was executed, combustible materials were permitted for use on buildings over 18 metres. 42.14, relevant building regulations were set out at paragraph 35 of the amended particulars of claim. Key provisions were, and then we have their reference to B3.4 and B4.1, functional requirement B4.1. And then 42.15, to give guidance on possible ways of complying with the building regulations. There's then MHCLG, published guidance, which is the approved documents of ways to comply. Over the page, 42.16, the approved document in place. January 2005 was approved document B, ADB 2000, and then 42.17, in order to satisfy the requirements of functional requirement B41 of the building regulations, paragraph 13.7 of ADB 2000, required the following. And then below that quotation, we continue with 42.18, the stove-therm system at the towers was applied directly to the external wall surface. without creating a ventilated cavity. The plea goes on over the page. The conclusion, punchline in a sense, is 42.21. The selection and use of combustible thermoplastic materials, including EPS, as insulation in the design and construction of the cladding works at the towers was therefore permissible and was reasonable and suitable, subject to the use of appropriate fixings and fire barriers. So when my learned friend says, well, the building regulations didn't change, that is true insofar as the Schedule 1 language did not change. But what was happening underneath that high level of generality, changes to guidance, approved documents, and so forth, was very substantially changing as between 2005, 2010, and in 2017, and so forth. And so it is that reason, that is the reason why the inquiry into the 3 workmanship defects pleaded originally, vis-à-vis the building regulations, for example, and the inquiry into the EPS case, which is the subject matter of the amendment, are substantially different because the building regulations Schedule 1 language is the same, but the lens through which one judges questions of, for example, adequacy are different. And so that is why there is this different inquiry of the sort that I've mentioned, which means that no, not same or substantially same facts and matters. And the inquiry is substantially different by reference to, for example, expert evidence. That's the first point. Second point concerns my learned friend's additional ground. He says that the essential factual elements are not changed by paragraph 41.6. But my Lords and Lady, I'd invite you, when considering your judgment, to look at the language of 41.6, which focuses on the and I quote, selection and use of EPS as insulation. That in my submission is not within the original plea. What is within the original plea is allegations of workmanship, alternatively potentially design, in respect of 3 specific elements, and not the decision to choose to use the EPS insulation in the first place. And that brings me on to my third point. My learned friend criticises the judge and points to paragraph 34 of the judgment, that's core bundle 43, as being in error. Perhaps we could go to that very briefly. Core bundle page 43. So my learned friend, on his additional ground, criticises that part of paragraph 34, which begins here, comma, the essential factual basis. And my learned friend says that there are 2 things that the learned judge omitted to consider. First, fixing of insulation is already a breach. Well, sure, fixing of the insulation is indeed an original pleaded breach, but that does not import or imply, or necessarily imply, criticism of the choice and use of EPS in the first place. Secondly, my learned friend says, well, the learned judge did not consider that the EPS is part of a cladding system. Well, it is also, of course, right that the EPS is part of a cladding system, but the gravamen of the allegations in the original particulars of claim were clearly, and I do repeat my verbs point, which is that they're all fixing and similar language, which is to do with implementation of a scheme of work, rather than a fundamental choice about what is to be used as a
They're used throughout. It's the same fixings throughout. Universal, systemic.
and I don't disagree with that, and that's absolutely right.
Isn't that therefore imply it's a choice? It's a design thing rather than a workmanship thing.
Well, with respect, my lord, we say no. It would seem that the relevant fixings were uniformly, so the allegation goes, were uniformly badly fixed. But that, in my submission, might point to a problem with the design in respect of those fixings. But it says nothing, it tells one nothing about whether there is a fundamental problem with the design, namely that the decision to use EPS at all was wrong.
Well, it doesn't necessarily descend to that detail, but the overlying thrust of the complaint is that the external wall isn't sufficiently safe for fire purposes. A number of reasons are given for that. You say this reason isn't one of them. And really what it boils down to is whether you look at it at that slightly higher level or whether you descend to the detail.
Yes, in my submission, for the purposes of whether this is a new claim in the first place.
Yeah, you say you've got to look at the detail because you've got to say why is it defective. It's defective because you chose the wrong cladding rather than because you didn't fix it properly.
Yes, and Malali, there's a practical, we say, reason why that level of particularity is sensible and necessary, because depending on the way in which the matter is pleaded, a defendant may be able to back certain things off against insurance or may not.
Yeah.
It's very unlikely that a building contractor will be able to avail itself of policies of insurance for workmanship. Design, very different story.
Yeah.
Fourth point, very briefly, it's said that as a matter of logic, I think, that my if, the use of the word if at the beginning of 41.6, that language of contingency, which Mulalley Forensics accepts, that it's not right to say that points necessarily to a new claim. That's probably right as a matter of logic, but my point was rather a common sense point and an ordinary use of language point, which is that if my learned friend is saying if the points on the defence are made out, then in those circumstances 41.6 arises. That can only be a claim that is made after sight of the defence. It must therefore be a novel claim vis-a-vis the original particulars. That was my point. It must be novel, as I think my learned friend accepts in other parts of his case. It's responsive to the defence. If it's responsive to the defence, it can't sensibly be described as having existed in the original particulars. Hence we say new claim. Finally, my learned friend, more recently in his submissions this afternoon, posed a practical test of does the amendment raise issues or areas of inquiry which would not arise on the original pleadings. That's a précis, not verbatim. We say if that's the practical test that this court is entitled to follow, then there are a host of areas of inquiry that will be triggered by the amendment and only triggered by the amendment and wouldn't otherwise arise. So, for example, whether the choice or use of the EPS insulation was itself a breach of the building regulations back in January 2005. That is an inquiry which will involve looking at Schedule 1 of the building regulations, looking at industry guidance as to what was regarded as fulfilling those requirements, and that may be very, very different. Adequate works that will adequately resist the spread of fire will look very different in 2005 in my submission from how that language will look in light of the various approved documents, the various guidance under the building regulations, the various matters which have occurred since the tragedy at Grenfell. A different lens will be applied to those matters. Now, I note that particularly Malali has referred to the building regulations as being obligations, or giving rise to obligations of a strict kind. But because of the way in which the building regulations at Schedule 1 are expressed, one has to get into questions of, well, what is adequate? And so
Well, I agree with that. It just struck me as being, see the way you put it, that there might be some room for debate at least as to whether or not questions of adequacy are judged by what was thought at the time or what's thought to be adequate now. Either it's adequate or it's not. It can't be good enough to say, well, we thought that it was adequate in 2002, but it turned out later that it wasn't.
well, Malali, there, in my submission, and perhaps this isn't a matter for this court, but before it's a matter for the trial judge, but certainly my clients contend that if questions of adequacy are to be looked at, that they have to have regard to how the building regulations were understood and guidance applicable at the time, as at January 2005.
Can I ask, on this point, can I ask this, and this is really a question for both of you. Just before I stopped being the judge in charge of the TCC, there were, because that was the end of 2017, the beginning of 2018, there were a number of claims which could be said to be Grenfell related. In other words, because of the fire at Grenfell, people were then looking at their buildings, and of course that's had numerous knock-on consequences. But I obviously, because I saw every claim that came in, there were a lot of claims, if you like this. I mean, using this as simply as a generic type of claim. And indeed, I seem to remember that I assigned Mr. Justice Stuart Smith, as he then was, to be the judge in charge of all of those. Obviously, he won't be doing them. But I wondered whether in your trial in March, is this the first, as far as you're aware, the first post-Grenfell, this is what we found as a result of Grenfell and here's the claim, type claim?
In broad terms, my lord, my understanding is very much yes, in the sense that it will be the first airing on duty, breach, causation, loss type basis of these types of issues, where there is a JCT building contract, design and build, where there are references to the building regulations, and there are fire safety.
I just wanted to ask that because I wasn't aware that there had been any, and as you know, just on the slightly wider point, that was a factor that I would have, I think, granted permission to appeal in any event, but that was a factor behind the grant, because it was, I was conscious that there's a lot more than just this case out there, as far as I'm aware. Sorry, that's a slight red herring, but in fact it's relevant to what you were saying, because you were talking about the room for debate and whatever, and if the appeal is unsuccessful, then those are the matters that, or some of the matters that will be canvassed at the trial.
Yes, indeed. If the appeal is unsuccessful, then of course the trial judge will be concerned with what we say is a substantial further avenue of inquiry, namely whether a design and build contractor in January 2005 deciding to use EPS insulation what was at that point in breach of various regulations and requirements in a way that building contractor would certainly have been in breach in 2017, 2018.
Okay. Well, that's very clear.
My lords, my lady, those were my points of reply. And as I say, conscious of the time.
No, well, if as I said before, it does seem to me that we have probably trampled the ground.
Yes.
But thank you very much. Right. Well, thank you both very much for those excellent submissions, and I think the time has broadly been divided between you, so that's good. Thank you for those sitting behind you. We will obviously reserve our judgments. We haven't talked about this, so I'll talk to my lord and lady after this. I think that the chances are, and I'm sorry if this is unhelpful, but the chances are that it is inevitable that those judgments will be prepared so that they will be, I would have thought, overwhelmingly likely to be available in January at some point. I can't do better than that, and I'm not sure that it would be appropriate or wise to offer anything else in terms of any sort of indication from the court. We couldn't do that today anyway, but I don't think actually that's appropriate. So you will be notified in the usual way. You will be sent draft judgments. As you know, those are for you to check the typos and our grammar, but not to re-argue the points. We will obviously gratefully accept any typos or grammar you point out. We would hope, having received the judgments, that you'd be in a position to agree the order. If not, if there are any points between you, very short written submissions on the points between you, and we'll decide those on paper. The hand down will almost certainly be remote, but even if it wasn't, if it was like the judgment I handed down this morning, there's no requirement for anybody to attend.
My lord, that's very helpful. And in relation to the indication regarding January, that is, for present purposes, well in advance of the trial. And as I've already indicated, the parties are proceeding on the basis that the amendment, as it were, is in, pursuant to the ruling of the judge. And so if I were successful on my appeal, there may be questions of scaling back the evidence before the judge rather than the problematic scenario of new evidence having to go in.
Yes. So well, we, as I say, I'm confident, both my lord and my lady and I, we all dislike judgments hanging over us. You're obviously in the last week of term, the last full week of term, so that has, I'm afraid, an inbuilt delay. But I'd be confident about January.
Thank you. Thank you very much.
All right. Thank you all very much.